All right. This issue of the 3 witness statements filed as part of Karen Cross's defense in this sex scandal, yes? Those statements have attracted a lot of discussion because they name certain key particulars have been, as we say, blacked out. The big word for it is redacted. Yes? The statements are purportedly signed by 2 justices of the peace. Yes? And we want to find out, is this an unusual occurrence for statements filed in defense pleadings to be redacted, and why would that be? Yes? Returning to one of the country's leading criminal attorneys, defense attorneys, QC Peter Champagnie. Good morning.
Good morning, Mr. Hughes, and good morning to your listeners.
Yes, sir. Help us here. Yes? First of all, is this an unusual occurrence for a person who is filing a defense? Yes? In their pleadings, their defense, they would submit a statement or 2 and with portions of it redacted. Is that unusual?
Well, let me just start by adding the caveat. I don't wish to comment, and I don't think you're inviting me to do so, to comment on the specifics of the
No, not at all. Not at all.
But to answer the question, it is not unusual. Our justice system consists essentially of 2 branches, the civil law and the criminal law. And certainly in respect of the criminal law, it is not unusual for witness statements to have redactions of the nature which you spoke of earlier. In fact, there is the provision now for special measures under the Evidence Act, where even in some instances, a witness may be permitted to give evidence or testimony behind a screen where the person's identity is not revealed. And that is supported by a number of cases or authorities in law. I think one of them that comes to mind is the Queen against X that was decided in 1989.
Here in Jamaica?
No, it's an English authority. And you will note I said the Queen against X. And that is because by the very nature of it, great lengths were made to protect the identity of the persons. But in that particular case, it involved a child that was deemed to be vulnerable. And the giving of the evidence was done behind a screen.
Yes.
And the defendants were charged with sexual offenses in relation to that particular child.
Yes.
On appeal, one of the grounds was that the judge fell into error by allowing this state of evidence to be given in the manner that I said. And the Court of Appeal in England held that it was entirely permissible having regard to the circumstances, having regard to also the vulnerability of the witness in question. Now, coming closer home, even in the civil arena, I understand that a defendant has responded in a particular way without giving details in terms of the identity of an individual is not fatal, because coming close to the trial of the matter, or what we in law would term as a plea and case management session, where you get directions in relation to certain matters concerning the case in terms of readiness, an application can be made for greater particulars to be provided, and the judge can make a direction. So it is not fatal, it is not unusual in this jurisdiction.
So, Mr. Champagnie, will there come a time when those persons who have submitted these redacted witness statements have to be presented in court and say, listen, I am the person who made this statement?
Well, it is really up to the other party. The other party is well within his or her rights to make an application before the judge to say we need to see the persons who are accusing us, and we need to hear their names and so on, so that we can verify their existence and do our own inquiries. Nothing is wrong with that. But for the moment, to say that the redactions in and of themselves is something that is fatal to any case of this nature, I think it would be not correct to represent it as such.
But in a matter in which so much turns, on those witness statements, in any matter, hypothetical matter, where so much turns on that, wouldn't it be almost a certainty that they will have to come forward?
I wouldn't say that. It would depend on the level of vulnerability. It would depend on a number of factors that a judge would have to then exercise his or her discretion. But certainly, it would be something that would be at the forefront of the defendant's mind in terms of legal representation to make an application and to make the very point that you're making, that it is important for these persons' names to be published so that we can know who the persons are in terms of their existence and deal with it accordingly in terms of preparing the case to confirm or substantiate their story. But it is not by any means fatal at this stage.
What about the justices of the peace?
Yes.
Who it is purported to have signed these?
Yes.
What is the legal requirement in terms of process to make it a valid document?
Well, hypothetically speaking, if there is just a blanket statement by the Justice of the Peace to say, well, I hereby certify that Mary Brown attended upon me, and I witnessed Mary Brown's signature, and I inspected her identification, and she was of a particular age, that may not be all that, it would suffice. I can see heavy weather being made of the fact that there would have to be what in law is known, certainly in the criminal law, known as a certificate or declaration, where it would have to go a bit further to say that the person who attended and gave the statement, that it was read over to the maker, the person signed it as being true and correct, knowing that if tendered into evidence, anything that is stated therein, if they believe it to be false or know it to be false, they are liable to prosecution, and that the statement was given of his or her own free will and accord. There was no influence or promise or favor. So you'd have to have, ideally I would say, you would have to have that kind of certificate in terms of detail. But again, you're speaking about the civil arena, and what is there. If it is less than that, then it is really up to the party's attorney, legal representative, to make an issue of those particulars. But ideally, this would have been the standard that I think would have been appropriate in the circumstances.
Going back to the point you made earlier about when a matter. I have to take the break? Okay, can you give me 5-10 more minutes, Mr. Champagnie?
Yes, sir.
Okay, let's go to the break and come back.
Hands were steady, my eyes were clear and bright.
Take Histol Elixir for fast, effective relief of runny nose, sneezing, itchy, watery eyes, and other allergy symptoms. Histol, distributed by Massey Distribution. The time by Histol Elixir is
17.5 minutes after 11.
Want a real vacation? Then visit Jake's Hotel, Jack Sprat and Lover's Leap for an unforgettable experience. Jake's offers rooms, cottages and villas at affordable rates. Dine at Jack Sprat for the best in seafood and their world-famous pizza. Visit the newly refurbished Lover's Leap, new restaurant and bar overlooking 1,700-foot view and dubbed the most romantic place in Jamaica. Telephone 876-965-3000.
Flow is connecting Jamaica to fiber-fast internet.
Over 250 communities island-wide have received upgrades since last year, with many more to come. Flow is committed to giving more Jamaicans better internet access. And with over $40 billion invested, our network grows stronger each day. Visit your Flow store today or call 1-800-804-2994 to find out if you can upgrade to the fiber-fast experience on Jamaica's largest network.
Sealand Foods International Company Limited, located in Crawford, Long Acres, St. Elizabeth, is the complete source for seafoods, meats, and value-added food products. Established in 2003, their reputation was quickly associated with quality, efficiency, innovation, and excellent customer service. Sealand Foods strives to provide their customers with the highest quality food products available. They distribute island-wide to hotels, restaurants, supermarkets, wholesale, and retail outlets. Telephone 876-649-0963. Fresh from the ocean and the land to the pan.
Hi, I'm Lloyd Gale, inviting you to join me weekdays at 12:55 p.m. on Nationwide 90 FM for
Oasis. Stop by for a refreshing drink and share a God perspective for the day.
Experience the change when you love the Word, learn the Word, live the Word.
Oasis, weekdays at 12:55 p.m.
on Nationwide 90 FM.
The rebroadcast of the Oasis can be heard weekdays at 5:45 a.m.
My hands were steady.
We're talking with Queen's Counsel Peter Champagnie on the issue of witness statements, parts of which have been redacted, and how that is likely to be managed or processed in the courts, right? Mr. Champagnie?
Yes, sir.
Yes. So, in the matter of the redacted statements, tell me, by the rules of procedure, do the original statements would have been submitted to the registrar without the redaction?
That I can't speak to. But what I can say is that when it approximates a trial or a plea and case management hearing, the necessary applications, or as the party deems it necessary, the application can be made for the names to be provided if it is that they were submitted in that form. But it can be submitted in that way. There's nothing wrong with that. Mm-hmm. And as I said before, at the appropriate time, the necessary applications can be made.
All right. So, help me now. Hearsay. In a matter where Hughes is being sued for defaming Peter, yes?
Yes.
Saying Peter is this and that, yes? And Hughes now, as part of his defense, says, I have to provide the witnesses who can confirm my allegation. In that circumstance, doesn't Hughes have to deliver the live bodies in courthouse?
Not necessarily. As I said, there are no provisions in law where the evidence can be given by way of video link, special measures. So to answer your question directly, no, not necessarily. It depends on a number of considerations. The age of the person, whether or not there is grounds for the judge to rule that the special measures application in terms of the witness giving evidence by way of from a remote location is appropriate in the circumstances. So a number of factors would come into play in terms of the determination of the matter.
And of course, you're making a distinction between physically live presence in court as against a video link, a Zoom link, or whatever.
Correct.
But in essence, the person will have to be there to say, yes, Peter did do this to me or not.
Yes. One would expect that to be the case, and if that is not the case, then I would expect the opposing side to take a point in relation to that, and the judge may well determine the matter in favor of who is making the application. redaction based on other attendance circumstances, of course. But it is not unusual to have documents filed with redactions. It's not unusual in the civil court, and certainly in respect of the criminal court. It is very, very commonplace these days.
Okay. Thank you very much, Mr. Champagnie. I appreciate that. Yes, I hope that was useful in adding a little bit of clarity to that aspect of this hot button issue.